Good morning. Thank you for joining us for today's 2021 Virtual Employment Law Symposium. We've got a full virtual house and a packed agenda, so let's dive right in. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides for the second and third sessions of the symposium, and we think it'll be helpful for you to be able to see both the video and slides at the same time. To do this, you may need to make one adjustment to your view settings when we get to that point in the agenda. Find the View Options button at the top or bottom of your screen and click it to see your options. Then you can choose side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You'll then be able to slide the separator to the left or the right to adjust the size of each view. If you have any issues with video or sound quality during the symposium, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We've also scheduled a short amount of time at the end of the program to answer questions you may have live. If you have a question at any time during the symposium, please type it in the Q&A box and we'll do our best to address as many questions as possible during the Q&A discussion. Now I'll introduce Ken Gray to kick things off. Ken leads the firm's labor and employment practice group, and his practice experience encompasses various areas of employment-related litigation. Ken, the floor is yours.
Thank you, Jen. Welcome to our annual Labor and Employment Symposium. Typically, we're in person and enjoy interacting with folks one-on-one, but in this situation, we're virtually this year, and we think we have a very nice agenda, and it is action-packed. So I'm going to go ahead and jump in, and our first presentation will be moderated and led by Devon Williams, who is one of our firm's managing directors. Devon does just about everything in our section. She handles any type of employment issue you can think of, including wage and hour, federal contractor compliance, employment discrimination, harassment and retaliation claims. She advises clients on employee discipline and termination decisions, personnel policies, practices, restrictive covenants, and background checks. So we welcome Devon this morning. And we are just thrilled to once again welcome Tom Colclough, who is the District Director of the EEOC Charlotte District, which encompasses not only all of North Carolina, but all of South Carolina and Virginia as well. Tom has a long and distinguished career in service to our country. He was a graduate of the military's Command and General Staff College and the Office of Personnel Management's Federal Executive Institute. Tom retired from the North Carolina National Guard after 23 years of service, both active duty and reserve, at the rank of Lieutenant Colonel. And as always, Tom, before I complete the rest of your bio, I want to thank you for your service to our country.
Thank you, Ken.
You got it. And beyond the military, Tom's also served our country with over 25 years of experience with the EEOC, investigating charges and complaints of discrimination and leading very high-performing teams. He served in a number of leadership positions at the EEOC, such as enforcement supervisor, local director, area director, systemic coordinator, and most recently, prior to becoming the district director, he was the deputy district director. So with that, I am sure you're going to enjoy this very interactive process between Devon and Tom. Take it away, guys.
All right.
Thank you, Ken. Well, Tom, I know we've had some conversations leading up to today, but I want to give our audience a little bit of a foreshadowing into some of the things that we're going to talk about. We have a jam-packed discussion, and so I want to dive into that. And I'm so appreciative to you, Tom, to joining us again and helping our audience hear from you and your experiences with the EEOC. And we've had a little bit of some changes going on over the last year and a half. some groundbreaking things. And I know every aspect of our world has been turned upside down in some capacity. And the EEOC has kind of been at the center of it with a lot of the things that we'll touch on. Before we dive into some of these exciting topics, we're going to talk about COVID and vaccinations. We're going to talk about social justice and systemic racism and what the EEOC has seen and what the EEOC can do to help. Diversity training, LGBTQ plus rights, pay discrimination, Equal Pay Act, and the Paycheck Fairness Act that is possibly on the horizon. So as you can see, we have a lot to dive into. But before we get into those particular topics, Tom, I would love for you to share a little bit about your experience and time at the EEOC. I think, a lot of folks know the typical EEOC process, but they might want to see a little bit behind the curtains if you're willing to share about that. And particularly maybe over the last year, how things have kind of morphed for the EEOC.
Absolutely, Devon, and good morning to you. Well, at EEOC, we have done some changing over the last few years, especially during COVID. March of 2020, all of EEOC, 100% of us, we went to telework. And so we have been working 100% telework since that time. The Charlotte district is typically one of those districts that we like to pilot a lot of projects and initiatives for the agency. And one of the initiatives that we piloted a few years ago was to go to a digital platform. The other thing that we did within the Charlotte district is we work with Fair Employment Practices agencies. We call them our FEPAs in Virginia, North Carolina, and South Carolina. And we work with them a year prior to get them to 100% digital. So, we knock on wood because we think that even with COVID, we were prepared. And right now, our process is 100% digital. One of the things that we do is an individual is able to file their charge going through our portal to start the process. They can schedule the interview. The interview is, conducted, via the phone. We use Microsoft Teams. The charge is then signed digitally, and we serve notice to the employer using a digital process. The other thing that you're going to learn about on Monday of next week, or probably over the weekend, is we're going to start issuing notice of right to sues digitally starting on the 10th. So that is on Monday. So what that means is we will not be sending those out, right to sues and other closure data through US mail. It'll be strictly through the portal. That'll get us to 100% digital in our process. The other thing is that EEOC, we don't represent either side, as you know. So one of the things that's really important to me, as I said to an employer yesterday, to me, I'm not necessarily concerned with what the end result of the case is. What I'm most concerned about is that both sides feel that there has been fairness through the process. So for me, it's important that the investigators, are they asking for information that they actually need? Because if they're asking for too much, then myself and other managers, we need to know that. The other thing is if we're doing negotiations or settlements, and Devon, here's something that became a nightmare to me when I was reading it recently, that someone asked in a conciliation agreement for 5 years for EEOC to do a compliance review. That's too long. That's way too long. And that was for a simple one basis, one issue case. It sounded like a great idea, but I think it put too much burden on the employer. Plus, it put too much burden back on the office director to make sure that compliance is done, and of course the parties who may have filed the charge. But again, with EEOC, as you know, we have, and I'm going real quick, we have really like 4 different departments. I like to think of it as is that the majority of our cases that come in, they actually go to mediation. If an employer is not granted mediation up front, they can always make a request for mediation. They can either make that request to me or the office director from which the charge came. And we'll review that request and make a decision as to if the case can or cannot go to mediation. We're about 99% yes if an employer asks for mediation. The other unit we have, of course, is the enforcement unit. That's where the investigations are done. That's where that's where all of the investigators reside. The other good news is we're about to hire about 11 more investigators in our district that will help us speed up our process. We also work very closely with our legal unit, and we like to call it legal enforcement interaction, meaning we're trying to always talk about and talk through what's happening with the cases, because again, we want to make decisions as quickly as we possibly can. And the other process that we deal with is the federal sector process, which Anita Richardson is our supervisory administrative judge that handles that. And so that's one of my new things that I've been doing probably for the last 4 or 5 years, is working with the federal sector process, which is completely different than the private sector. Private sector, 180 days to file a complaint. Federal sector, they have 45 days.
Yeah, no, that's fascinating. Thank you. Thank you for that overview, Tom. What kinds of things, just talking about the typical EEOC process, are there particular things that you see or that your team sees that raises a red flag right off the bat for an employer that they should be aware of? Easy kind of fixes or preventative action that they could take to avoid being in the crosshairs, however well-meaning the EEOC is. I think most of the folks on this this call would like to avoid having to work with you in that capacity, although I'm sure they are enjoying this conversation.
Right. Well, to me, one of the things I've always believed in, you know, I've been working with your firm many, many years, and what we've always developed, we developed right off the bat. We have a good relationship. And I think that's what EEOC and employers are all about, is having that relationship. Meaning if there's something that we need, we reach out to you, Devon, and if we can explain to you why we need it, you've always said, sure, no problem. I think there were sometimes employers can go awry is if they say no, but they don't tell us why the no. Again, it is our responsibility to tell you why we need it. But again, trust me, if we need it, then there's a reason for it. So the other thing I would say is this: if something actually went wrong in the workplace, my belief, be humble and just admit it. That's the easiest and the best thing to do, because once we just admit it, guess what we need to do? How do we fix it? I think at EEOC, at least for me, guess what I'm not interested in? I'm not interested in how many violations we issue. I'm interested in our mission, which is to stop and remedy unlawful employment discrimination. So if we can fix it and we can fix it together, for me, that's the plus. The other thing is that, and again, I'm going to use your firm, Devon. When you prepare a position statement and send it to us, especially with the investigators, you speak in plain language. You speak in how our compliance guidance is written. The investigators can understand that. The legalese, as I tell all of our investigators, we don't need them to be attorneys. We got attorneys. We need them to think in terms of what is the agency's guidance. And I thank you and your firm, Devon, for always doing that, because it makes the process go a whole lot better.
Well, thank you, Tom. Appreciate you saying that. So moving on to another change that's happened in the last 6 months, and we talked about this recently, but I understand there's a change to how the conciliation process is being handled. And at first blush, you might think it's less favorable to employers, but I understand that it gives us more transparency, and hopefully there's still that opportunity to try to work out a resolution after the fact if there is a cause finding. Can you talk a little bit about the old process and the new process that you all have implemented within the last few months?
Absolutely. The old process, kind of what we were doing is that we'd issue a violation, conduct a predetermination interview with the employer. And sometimes those predetermination interviews came through an email or a voicemail. And we decided with our new process, that's not going to happen. That the predetermination interview, and I'm looking at my flow chart, because for me, Devon, I'm one of those visuals. I had to actually draft a flow chart based on our new rule to put out to everyone. But after we determine that a violation has occurred, we send that back to the enforcement unit. That's if, because it has to go through the hands from the investigator, through their supervisor, to their director, and I review a percentage of those cases just to determine whether or not there is or is not a violation. But then we conduct a predetermination interview before we mail that determination. Again, we're going to do that verbally. And if we can't get it done verbally, we're going to reach out to say to you, Devon, first of all, to say, hey, we need to talk to you, Devon, so that we can schedule a time to do that verbally. The other thing that we're doing is a little different. As sometime in the past, as you may recall, when we issued a determination, we would send a letter stating what we were seeking in conciliation. We're not going to do that anymore. So no conciliation information will go out with the letter of determination. The other thing is that the employer will have 10 days to consider whether or not they want to participate in conciliation. The thing I would say, the investigator, what I've told the folk in the Charlotte district is, let's say we don't hear from the employer within those 10 days, we're going to reach out to you again, Devon, because guess what? Life is busy. So we'll reach out to you again. Our guidance kind of says that we can say if we don't hear from the employer, we can just fail the conciliation. But we're not going to do that in the Charlotte district. We will make that reach out. The next thing we're going to be doing is, while we're waiting for the employer to decide whether or not to participate in conciliation, we're going to be conducting a damages interview with the charging party or his or her attorney. The thing that's important to know with the damages interview is that I look at it as a three-legged stool. When we start talking about conciliation, the employer kind of has an idea, once they decide to go to conciliation, what they're willing to offer. I get that. That makes total sense to me. But then also that the charging party or if they're represented, they're also going to have an idea. Now, what's important to know is at the conciliation, it's what EEOC values the case at, not what the charging party or their attorney values the case at, because that's what we're going to seek, because again, we have to negotiate in good faith. Once we conduct the damages interview, we hope that the employer has responded. If the employer says no to conciliation, we will then decide whether or not we're going to issue the charging party a right to sue, or are we going to send that case to our legal unit for litigation. If the employer says yes, what we're going to do is send out a kind of a draft proposal. And in that proposal, we're kind of going to tell you, hey, here's a summary of the case. Here's a legal basis for the decision that we made. Here's a proposal of what we're seeking. And we're going to give the employer 14 days to say, yep, I still want to participate. And if the employer says yes, we're going to schedule the conciliation, and we're going to get into the room, or better yet, sometimes now the virtual room, and do the conciliation. The key thing that's always important is, as someone used to say to me in the military, I look at the conciliation as a plan, and a plan is always just a starting point for change, meaning everything that we're asking for, we know that we're not going to get that in conciliation, but we also know that we're not going to give up.
Looks like Tom's screen might have frozen for hopefully just a second. I'll fill in, because I know he was adding to that to suggest that the part of the conciliation where there's still some back and forth and negotiation that can happen, that will still happen. That is still part of the process, and that comes at the end. This is hopefully to add more transparency for employers, respondents, and to streamline the process so that the EEOC is not engaging in adding too much detail on the front end, and when an employer may not be interested in conciliation. So if you have encountered that situation in the past, it's probably going to be a little bit different going forward. I understand from Tom that his department is still, his district is still working out exactly how they want to handle that in accordance with the new rule that came down. So that I wanted everybody to have a chance to hear that from Tom himself. And that new rule, that new process went into effect in mid-February. But with the pandemic and COVID and the vaccines, it was likely you may have not heard about that. And that could be a good thing that you haven't heard about that. So I'm going to give Tom just a second or two, hopefully, to be able to reconnect and let you know some information that I'm sure he will share too. But if you have not visited the EEOC's website that has a list of questions, Q&A of issues relating to the pandemic and all of the issues that have arisen, it is worth going to that website if you have questions or just you're not sure how the EEOC interprets some of the requirements that have come down and what employers are supposed to do. And I understand from Tom, there's new guidance actually supposed to be coming down in very short order. He might be able to give us a little insight into some of those, the new guidance that will be added to the FAQ on COVID and vaccines. Ken, you want to add?
Yeah, and as Tom is trying to get reconnected, I was just talking to him right before the symposium and mentioning that we had a client that got an EEOC charge on Monday. We gave notice of representation. On Tuesday, they sent the offer of mediation, and we accepted on Tuesday. And then yesterday, we received the request from the mediator to go ahead and schedule the mediation, and we're actually mediating the claim on this coming Tuesday. So we may resolve this case in less than 10 days from the moment that the employer received the charge. So Tom is really working on streamlining the whole process, and I'm sure there are many folks on there on the call today that have dealt with charges that lasted 6 months or longer. And Devon, we've seen them go as 18 months. And so I think that's hopefully going to be a thing of the past, and these things will not be lingering along quite as often. And I see Will has joined us as well to get some input.
Yeah, good morning. I just wanted to, while I could share this while Tom's not here, and it doesn't sound like I am giving him too much credit, but he also sits on the North Carolina Bar Association's Labor and Employment Section Council that I'm a member of. And I will tell you, he comes to the meetings and he hears not only what the plaintiff's attorneys say, but also what the management attorneys say. And I truly believe he builds that into the way that he runs the organization. So I would just say, we're very lucky to have him in this role. He is very pragmatic. He has a job to do and he does it very well, but he always has, an open door for employers and management attorneys. And I just can't say enough nice things about him. The other thing I'll say is, if you have the pleasure of mediating one of these charges with Vanessa Mollett, there is not a better private mediator out there. And I'll say that as a certified mediator than her. So all that to say, I can't say that's about all government agencies, but Tom does an outstanding job. So with that, I'll stop before he gets back on.
Yeah, we won't tell him you said that, but I agree wholeheartedly with Will. Tom, I've had some situations where an investigator, in my legal opinion, I feel like the investigator has reached the incorrect conclusion on a case and regarding the facts, and maybe weighed certain facts over others that we found to be more credible. And I've picked up the phone and called Tom. I've met with Tom in the middle of a conciliation to say, hey, let's talk, because we respect Tom and his thought process, and we know that he works very hard to keep everyone within the EEOC in line with his thinking of being impartial and ultimately trying to eradicate and prevent unlawful harassment and discrimination. And so one of the things, hopefully when we get Tom back with us, one of the things that we'll talk about are ways that the EEOC can actually help preventatively. And it's not a red flag or a spot on your record to reach out to Tom and ask those questions of how might the EEOC help so that you can avoid, for example, systemic discrimination or harassment. And that is something that the EEOC has always prioritized, that when a charge comes in, they look at, is this a one-time individual basis type of charge, or are there facts that suggest this is systemic? And they have a different investigation process if it is an individual charge or if it is a systemic charge. And so that is something that, you know, Tom will be able to share a little bit more with us as well on that. Tom, thanks so much for joining us back. While you were gone, I'll share, Will gushed on you a little bit and gave you some compliments, and then he quickly ducked off so that you wouldn't be able to hear it. But the audience
Okay.
now, the gig is up. The audience knows that you're wonderful and you do a great job with the EEOC, and certainly a friend to us in helping employers prevent and avoid discrimination and harassment for everyone. So glad you're back. And if it's all right, I figured we could jump into the wonderful topic of COVID and vaccinations. And I shared a little bit with the audience that I understand there's some more or new guidance that will be coming down from the EEOC here soon on vaccinations and kind of hopefully getting us out of this pandemic and what employers need to be doing. But just with COVID in general, have you seen an uptick in EEOC charges that allege some aspect of discrimination or harassment arising out of COVID or related to COVID?
We have not yet. Again, we do have some cases regarding COVID. I am expecting, and first of all, let me apologize. I don't, you know, I'm in the country in Clayton today, and our internet went out for whatever reason. So I apologize. But right now, you know, we have some COVID cases. But what we're expecting as the economy opens back up and people start reporting back to work, that we're going to see an increase in COVID cases. I'm sure that you've heard it, you know, at a lot of workplaces that there are a lot of employees that don't want to return back to their work environment. You know, for various reasons. You know, some of the reasons are they're comfortable working at home now. You know, and you know they got that to a new normal. The thing that's really that we have to be cognizant of, though, is that, you know, there is going to come a time, and you know, North Carolina is one of those states that's kind of in the forefront of getting vaccinations done. And I think there's going to come a time when, you know, employers say, "Hey, it's time to come back." I was looking at a funny video yesterday of someone. I think it was a chewing gum commercial, and it was talking about how people were coming back to work. You know, and it's going to be different. But I think that the thing we have to think about is those people who say they can't come back to work. You know, is it based on a religion? Is it based on a medical condition? And if the employer says no, what I would say is, if it is based on religion, do the analysis. If it's based on a disability, do that individualized assessment. Because again, the thing that the employer needs to look for is it job related? Is it consistent with business necessity? The other thing is that I think we're gonna have to think about that thing called the interactive process. Talk to folk, figure out exactly if they say they can't come back, what's the reason why they can't come back. And as before, the ADA has not changed. If you need documentation, I would say you need to request the documentation. And again, you know, the other thing I would say, though, on the flip side, is as the employer, think about the compassion thing. Some people might not want to do it because they're afraid. You know, they're completely frightened. I get that. So long story short, Devon, I'm expecting we're going to see an explosion. One of the things that I learned about last week, as a matter of fact, when you and I talked, was on Monday, was I'd gotten an email right off the bat that in the western part of our state, that there were employers who were not allowing people to return back to work unless they could demonstrate and showed their COVID vaccination card. Is that going to be okay? We're going to have to see. But again, I do think that right now that we have to, when we think about COVID, I'm trying to get the fancy word we use for it. And I'm looking at my little slide real quick. Is it a direct threat for the workplace? Because again, let's say that you have most of your workforce is not vaccinated, and you have people that say they don't want to get it. Well, I think that the employer can still, ask those questions. Has a person been around someone who's been exposed? But I think we have a long way to go with COVID. I think it's going to be a test, but the thing I would urge all employers to do is to visit our website, to read the guidance that we have put forth on COVID, and to look for that guidance that's coming out soon regarding vaccinations, because I do think that that is a big thing. I see something in the chat, Devin. It says, I'm not good with the chat, Devin. Has North Carolina House Bill 686 that will protect unvaccinated staff. Well, can you still hear me, Devin?
And yes, and I'll chime in on that too with you, Tom. I think from the EEOC's perspective, Tom, you're looking at Title VII, ADA, ADEA, federal laws that govern employers, oftentimes with Title VII, and it's 15 or more employees over a course of a period of time, and so there's a threshold, but that is federal law, and you are a federal agency, and so certain state laws are unlikely to preempt or trump the federal law, and so federal law will still remain supreme. And so there's certainly a balancing act if there are state laws that arguably could conflict or be inconsistent in a particular fact pattern and situation, not necessarily that they conflict on their face. And I think, something, Tom, as you're talking about this, I'm thinking, there is, I remember some person early on in my career said, oh, you will do great with labor and employment because oftentimes it's based on common sense and a good heart. And while that's true sometimes, that's not, nowadays with all of the different laws that we have, that's not true. Having a good heart, having a good reason for wanting to get folks back or wanting folks to get vaccinated, maybe you believe that's common sense, but that's not always the case. But, as you're talking about it, it's not necessarily a one size fits all approach.
No.
And you can have a kind of general umbrella rule of, we want to require vaccinations. And based on the guidance, the EEOC says, technically, yes, you can mandate the vaccines. Now, there might be some more guidance coming that might add additional information on that. But if there are folks who come forward with objections, particularly religious belief objections or a medical condition as to why they're immunocompromised or whatever it could be, they come forward with something saying, I can't get the vaccination or I don't want to. The employer can't necessarily have that, line in the sand of, well, you're fired. You have to go through the interactive process. You have to have that discussion and being open about that. And so, I think this is an issue where there are oftentimes we joke about attorneys in general. If you have 50 attorneys in a room, you're going to have 49 opinions on every single issue. And I think with COVID, we've seen and vaccinations that can be true of people. There are a lot of different opinions. There are a lot of different beliefs on it. Mm-hmm. And unfortunately, employers are in that position where you've got to be able to navigate that and treat every person as an individual and providing accommodations where you can. One of the things that I was just curious if we talked about requiring proof. If you require, do you have an opinion on if you require proof of a vaccine, that you got the vaccine? Do you believe there's any need for an employer to record that, such as by taking a photocopy of it and putting it in even if it's a confidential medical file? Is there any reason from your perspective with the EEOC why an employer would actually document by making a copy of a COVID, if we call it passport, but the vaccine card? Any reason for that in your opinion, or you think that creates some unnecessary issues for an employer?
I think that it creates some challenges for the employer. But it goes into that old saying, just because you can doesn't mean you should. Do I think that the employer probably can do that? Probably. They could probably do that, to determine whether or not the person has actually had a vaccination. And again, I'm just speaking hypothetical because again, for me, the question is, can the employer exclude the person from the work site if they cannot be vaccinated? Well, as stated, again, you've got to look at, whether or not you need to provide the accommodation. But I do think that if the person can't get vaccinated or tell you they can't, for me, you got to give me a reason. If I'm looking at it from a direct threat standpoint, or is it going to create an undue hardship for me as the employer? And I think that absent the undue hardship or something under Title VII or the ADA that precludes the person of why they can't, then the employer is going to be able to exclude that person from the work site. The one thing I would always say to employers nowadays is that when you're thinking about that accommodation, though, remember telework is an option. And guess what the employee is going to be able to demonstrate? That they did it for a year. So it's going to be hard. It might be a little harder to say no. But I'm not going to say that that's not in all situations. It's not going to be a yes. Some situations it's going to be a no. One of the things I always think about when I think about COVID right now, Devon, is a lot of employers that are doing 100% telework, they're still paying for the brick and mortar. The landlords have not said don't pay us anymore. And so I think that there's going to come a time the employers are going to say we've got to come back. But I think the workforce and the workplace will just look different. It may not be everyone working all at the same time. But I do think, with regards to your question, the vaccination, it is a question that we don't have all the answers yet. And the reason why we don't have all the answers is, some of us are 100% vaccinated, but we don't know what the results are going to be. As someone said in the chat, yeah, some people have received COVID. Hey, I don't think that the vaccine says that you are protected 100%. It just says it is this percent effective. Do I think you're going to see that? Absolutely. But I think that COVID is teaching us some other things about how we embrace the work environment and how we deal with things. Again, flu shots. For years and years, guess what? People didn't get flu shots. Some people did. How do we handle it? I think that might be how we handle COVID going forward, but we'll have to see. But do be on the lookout for that guidance that our folk in the Office of Legal Counsel are writing as we speak.
That's great. Any intel you can share of what might be in there specifically or timeline?
No.
Fair enough, Tom.
but guess what? Timeline, I am hopeful it will be out sometime this summer. Okay,
great. Well, thank you, Tom. Very, very helpful on that topic. And I know that's a big one for employers right now and maybe for some period in the future as well. I want to shift gears a little.
Can I say one more thing though, Devon, on that? Because I want to echo what you were saying. Consistency is the best policy. Follow the law, follow your policies, but make sure you're consistent with every single employee of how you're going to apply that standard.
Yeah, so that you don't avoid the disparate treatment type.
Correct.
Of where the inconsistency, while on its face, it might solely be about COVID and the vaccine, but then we have an individual in a different protected category who says, wait, Joe Schmo got this treatment, I've gotten a different, here's the difference between Joe and myself. So absolutely, Tom, I agree. That's very important. Mm-hmm. So shifting gears a little bit to another issue that it's always been on the horizon for the EEOC and a priority of the EEOC, I know with your mission, but systemic discrimination. And I feel like that has come to the forefront a little bit more in the last year as to systemic racism. Are you seeing an uptick in charges that on their face allege some kind of systemic discrimination or harassment from an employer?
I would say not on the face of the charge. There are times that an attorney may send in a charge and they may indicate that they feel that there's a systemic issue. The thing that and I actually did this around the dinner table a couple of weeks ago. For whatever reason, we got into a conversation about systemic racism. And for me, the way I always like to approach it when I was systemic coordinator is that disparate treatment, that is intentional discrimination that you've got to prove. Disparate impact, which leads us to systemic discrimination, those are times that things are not intentional. They just happen because they happen. And are things happening in America today? Absolutely. Are all things intentional? No, they're not. And especially with workforces, and when I think about workforces, it's based on migrations of where people live, where people want to work. So all those things go into it. But have we seen an uptick? No. Are we always looking at those things? Absolutely. For me, whenever I drive out, as a matter of fact, when I was getting my second COVID shot, the place where I got the shot at, they were doing construction at the site. And of course, the employer's name is on the side of, they've got a big sign, who's doing the construction. Well, I know I wear glasses, but I do have two eyes also. So I'm looking around and I'm looking at the workforce. And the workforce looked all the same. They were all of the same race. Now, that's either by accident, coincidence, or intentional. And for me, because you know what I did, Devon, as soon as I got back home, I did just a census check. What does the census say in this particular city? Who lives here? And statistically, who lives here? And you can, and everyone is using the same census data. So unless people dropped out of the sky upon that city, something didn't seem right in that particular industry. So of course, I decided to drive around the next day to other construction sites just to see what I saw. And guess what I saw? I saw the same issue in a lot of different companies. And so in my further research, then I learned that some contractors were getting the work and then they were subcontracting the work out to other people. So the question is the contractor, especially if that's the employer, are you aware? And are you now a joint employer? So again, to me, that may be intentional, but it may not be intentional. But one of the things that I try to do, and I've asked our systemic team to do when we're looking at a systemic case, even if it's racism, is to have a conversation with the employer early on. Again, we don't represent either side, and we just need to be totally honest. Again, with that particular employer, of course, I reported that to my systemic team. This is what I saw. I want you guys to think about this right here. And with that particular employer, guess what we would do? I would say, go have a conversation. Maybe they are just not aware of what's going on. Maybe they're not aware, or maybe they just didn't think about it, because guess what they were thinking about? We've got this contract, we've got to build this building, and we've got to get this building built in a certain amount of time, or we're going to be assessed fees if we don't. I get that. So to me, talk to the employer is what we do. Give them a picture of why we're there and why we think that there might be a problem. And if there's an opportunity to resolve it early on, let's resolve it. Because again, I think that we're the Equal Employment Opportunity Commission. We want the employers to keep employing people. We don't want them to be assessed tons and tons of fees so they can't, keep people at work.
Absolutely. And on that point, does the EEOC do outside of charges? If an employer, let's say in your example, you identified, company A that has possibly an issue with the makeup of its workforce. And so there may be some underlying discrimination or harassment issues. Does the EEOC ever approach that company and say, hey, here's how we can proactively help you so that you are not the subject of an investigation with the EEOC? I mean, are there ways to work hand in hand with the EEOC to try to prevent that if an employer identifies it as, hey, I've got something that I want to improve upon. I don't know how to do it. What do I do?
Well, in that situation, if the employer approaches us, yes, we will give them the answer. We will try to give them some answer. One of the other things though with the EEOC, we're a charge-driven agency. So there are three ways that we get charges. Either there are, especially for a systemic case, either an individual files a charge and we expand the investigation, or we do a commissioner's charge. And under Title VII, the ADA and GINA, we have to do a commissioner's charge, meaning the example I gave you, I just typed it up, I do an analysis, say, hey, this is how many cases we've had against this particular employer. These are the issues that occurred, and we send that to Washington and one of the 5 commissioners will review it and agree to sign off on it or not. And we're hopeful that if we go to that point, that they'll sign off on it. If it's an equal pay or a age case, then each individual office director in our district, they can initiate an investigation themselves on those 2 statutes. But once we have the investigation in hand, one of the things that we try to do is to come up with what are the solutions? Because sometimes, as I stated, when I think about systemic cases, it's normally a policy or a practice that is at hand. It's not intentional discrimination. Not always. It doesn't have to be intentional. So what we try to come up with is what actually, it's like cause and effect. What was the cause that made this happen? This is the effect. How do we change the cause a little bit? Good example, let's say that there's an industry, and in that particular industry, they have low minority representation. I'll use the IT industry. I was looking at something that Jerry posted a few weeks ago. It was a great article. And what the article was about was that an IT CEO had indicated he was going to change the diversity of his company by intentionally recruiting females and minorities only. Well, of course, that raised a red flag to him. It raised a red flag to me because it's like, wait a minute, you're going to violate Title VII. I know you think you're doing it, for that employer, that you think you're doing a good thing. Now, did we have a discussion at EEOC about it? Hey, do we want to go ahead and initiate a systemic case on this, or do we want to wait and see what happens? Because again, the first person that applies for a job at that particular employer, if they don't get the job, guess what they're going to use as their reason for not getting the job?
Yeah.
That
Even though it may
CEOs.
not be, I mean, it may not be that reason.
Exactly, but
Yeah.
they're gonna have a video clip. This is what the CEO said he was gonna do, and if they file a charge, now we're going to have to investigate it, and we're going to have to make it a systemic case, and then we're going to have to say, tell us everyone you've hired in the last, I don't know, year, and if it appears that you've hired women and minorities only, then we have to agree there's a problem. So even if that person may not have been the best qualified applicant, is still going to raise that red flag. So in that particular employer, if given the opportunity, what we would do is we would say, wait a minute, let's come up with some ways that you can recruit more folk, but you can recruit them fairly. Maybe you're not recruiting in the right place. Maybe you're not looking at, Meredith College over in Raleigh, Devon. Hey, it's all women's college. Guess what? Maybe you need to advertise, and post jobs there. Let them know about jobs. Maybe you need to do lunch and learn visits. Maybe you need to take on internships with folks. Meaning what I'm saying is maybe you can help grow your workforce by helping people understand what your workforce does. The other thing that we try to impress upon the employer is it is about brand image. Because let's say you have a systemic racism issue, that you think you have a systemic racism issue. Well, let's say you're a car dealership. The majority of your customers might be the same people that you're not employing. Guess what? That's going to be a brand image for you, especially if one person complains, your profits may take an immediate drop. So to me, you got to start thinking about those things. And yes, we've had cases like that. And what we tried to tell the employer there is you've got to come up with a campaign of how to reach out to your community. And you've got to engage people in that community to let them know that you're part of that community, and you got to change how you're doing your hiring patterns. The good news is most of the employers that we have worked with, that we've come up with those kind of solutions, we haven't seen any more charges. They tend to go away.
And that's good. That's very good to hear, that you help address the problem and that ultimately it does resolve that issue going forward. I want to kind of, this is a corollary topic, but on that same note, we've seen an uptick in DEI programs that are coming out, employers that are, or companies, I'll say, that are doing that, both externally, but also internally with diversity training. And I kind of would love to hear your thoughts and have you share with the audience some of what you've seen with the right way to do diversity training, and to prevent some of the issues we talked about just a little bit ago, as well as maybe if you've seen any programs that you think, without maybe naming who did it, but if you've seen anything where you thought, oh, that creates a problem in and of itself.
Absolutely. I have seen some good diversity programs. As a matter of fact, I spoke with an employer recently, and in their particular program, their program is going to last like 6 months, because you got to start with a culture assessment. But 6 months is probably good, but it's not the end. So what they were looking for was to say, we're going to do this for 6 months with our diversity and inclusion to build our program. And then you got to start bringing in other type trainings for your employees along. Now, some of the nightmares that I have seen is that the employer says, hey, we're going to bring a trainer in to do diversity and inclusion. It's going to last 4 hours. And what happens is their workplace is going to become chaotic. What I like in diversity and inclusion is it's kind of like someone going to basic training. In basic training, the minute you get there, it's a lot of yelling and screaming. But what they're trying to do is they're going to break you down. But in 8 weeks, they're going to build you back up into a system, of how the military does things. To me, that's why the employee that mentioned they had a six-month program, it made sense. It's got to take time. And then you got to make sure that you invest in it. I know I saw this one program. It was an absolute nightmare. It was sent to me anonymously, the program, and then all of a sudden, people from all around, our district start sending me. It's like, hey, I got this too. Take a look at it. And we all agreed 100% that you can't have a program that you are basically beating up on one, based on race, color, sex, etc., particular group in your workforce. That will not work. What that is going to get you is charges and complaints from everybody. And in that particular situation, charges and complaints from everybody. And of course, something that we had to report up to our headquarters, because we're like, hey, we don't know who, we kind of knew who wrote the program. And that particular employer, was their heart in the right place? Yes. Did they think it through? No. If I had had to make a recommendation to them, they would have called you, Devon, before they ever sent that out to a single employee. And I know what they would have gotten. I know they would have gotten the advice, hey, let's just think about this before we do anything. There might be something better out there that we can use. So again, for me, the long and short is make sure that diversity program does not lead to discrimination. And so you have to be very careful about, who you're getting diversity and inclusion training from. As a matter of fact, EEOC, hey, we're putting together our own diversity and inclusion training package, and you haven't seen it yet, right? Because we're being very thoughtful before we put it out to say, wait a minute, let's think about this. How do we approach it? How do we train on it? And you got to make sure you got the right trainers, because not everybody is a good trainer.
Yeah, I want to brag on Ken and Xavier real quick, Tom, to that point, because Xavier is actually going through, he's getting an Ivy League degree certification through Cornell in diversity, equity, and inclusion training, so that our firm can benefit from Xavier's expanded knowledge in that space, as well as our clients. And I know Ken and Xavier have teamed up to do diversity training for clients that have that interest, with the focus being on exactly what you're talking about. Avoiding discrimination, and that's in, from the EEOC's perspective, that's every category listed in Title VII, the ADA and ADEA. And so, I think it's a big issue. I think it's one we'll continue to see. I'm sure that I know there's a right way to do it, even when your heart's in the right place, and being thoughtful about it, I think is great. So we have just a few minutes, and I wanted to let you know, or ask you, excuse me, Tom, wanted to ask you kind of what you see on the EEOC's horizon in light of the administration change and the political changes we've seen over the last, now 5 months.
Well, I'm happy to say that EEOC is going to grow. I know our chair, Chair Burrows, one of her first acts in January is she authorized the hiring of 450 positions for EEOC. That's 25% of our workforce. That's how much of our workforce had dwindled. So that's phenomenal. Some of the other things that we're going to get back to is we're going to get back to the basics of what EEOC does. One is, we're going to be looking at systemic cases, but that's not new for the Charlotte district because we've had a systemic team for a long time. And so although that's a new priority for the agency, it's just something that we've always done. The other thing that we are looking at, and I know we're not going to be able to get to this topic, and that is equal pay issues. We're going to have an increased focus to look at that. The other thing is that I think litigation, might be something we look at, but not litigation for every case. That is litigation for the cases that should be litigated. Meaning we're going to, as we stated with our conciliation process, we've tweaked it, we've worked it. We think that it's a good process so that we can look for those opportunities to resolve those things that we can and only litigate when we have to. The other thing that we're going to be doing at EEOC is lots and lots of training, which is a good thing because we have a lot of things going on. As stated with the Bostock decision, hey, we know that we're probably going to see an increase in those type cases. That's okay. Why? Because at the EEOC, the Supremes just agreed with us, and we're happy that they agreed with us. That had already been our standard. Some of the things that we're hoping to deal with, and that is what the Bostock decision did not address, is those bathroom and privacy issues. So that's something that I know that we're going to be looking at probably coming up in the future. The other things, as stated, is technology. There's one thing you should know is that we're going to be changing our database. Our portal is probably going to stay the same, but how we do our internal database is probably changing. Why? Because we use a JavaScript database. Java's going away for everybody nationwide, worldwide in August. So we've got to adapt and change too. I think, again, with the new digital right to sues that are coming out, I think that everyone will like that a lot better. The one thing that I would just say is, make sure that if you're represented by counsel, make sure your counsel has the passwords to the portal so that they can get in and check those things. So I think the biggest things you're going to see is that you're going to see us more technologically advanced in all the things that we do.
That's wonderful. Well, Tom, thank you so much. I know I have learned so much being able to talk with you, and I'm sure our audience has learned a great deal. And so we are very appreciative to you to sharing your insights of working with the EEOC, as well as some of the things that you're seeing on the horizon and maybe what employers can do to hopefully prevent being the subject of an EEOC investigation.